How does franchise litigation work? I'm Doug Luther, franchisee lawyer from Luther Lanard. Franchisee litigation starts with the allegations, and the allegations are what you contend happened in the situation. So if it's a fraud, you might contend that somebody made a misrepresentation to you that caused you to get into the franchise. Or you might say that the franchisor didn't provide you certain support, an operations manual, training, marketing that you thought that they were required to. And at that first stage, there's what's called a motion to dismiss or a demur. And the judge or arbitrator is going to decide, based on what you allege, if we assume that that is true, does that give rise to legal claims? And so, just because the franchisor may have been a bad business partner or done something that you think is morally wrong, that's not the question at this stage. The question is, do those allegations give rise to legal claims, whether it's fraud, breach of contract, violation of franchise investment laws, and the judge will determine that and what goes forward in the case. Once we're through that initial pleading stage, we go into discovery. Discovery involves asking written questions as well as requesting documents. Now, when we ask questions, we typically don't get a lot of responses. We get a lot of objections. And so the real focus on discovery is asking for documents, and particularly internal communications on the franchisor's side. After we've done that written discovery, we'll now go into depositions. Depositions involve having the deponent sit down for a day and asking them questions, and also putting evidence in front of them. And our goal is twofold. One is often to attack the credibility of that deponent, and two is to obtain documents and other information that we might not have already uncovered. Once we've got through discovery, there may be what's called a motion for summary judgment. And a motion for summary judgment is to determine whether there's evidence to support the claims or rebut the claims. And if the evidence is all on one side, then you've got a chance to have that claim decided earlier before a trial or a hearing, based on the fact that there's no disputed facts on that issue or claim. If there are disputed facts, then it's going to go to a trial or an arbitration hearing, and that's often the case, particularly with fraud actions, because you'll have a he said, she said dynamic where one party says that someone said something and the other party denies it. And so at that point, you'll build up and you'll go to an arbitration hearing or trial where the judge, jury, or arbitrator will listen to the witnesses and decides who's credible. And based on who they determine is credible, they'll decide who has established their claim. And that's the nuts and bolts of franchise litigation. If you have any questions or would like to discuss, please refer to our contact information in the description below. And if you found this content helpful, please like or subscribe to our channel.